Так, дорогие, раз, раз.
One, two, three. Dear colleagues, I suggest we start. Today we are going to have a round table, a discussion devoted to historical heritage protection. And it's always very nice to see that the organizers of our forum always include a roundtable discussion devoted to cultural heritage protection. And this year we celebrate the 70th anniversary of UNESCO, and now we are sitting in the city, which is really a cultural heritage. And it is important to discuss all these things. I would like to welcome my colleagues who are going to participate in this roundtable discussion. Next to me, Sergei Makarov, who's chairman of the Committee on Protection of Cultural Heritage of St. Petersburg. Yesterday, we had great celebrations because it was the birthday of St. Petersburg. Sorry, I would like to apologize for this rain. Nothing changes in St. Petersburg. Rain is something typical. Yeah, it is part of this World Heritage. Then next is Sergei Mirzoyan, who is Chief Inspector of Cultural Heritage Protection from Mosgornaslediye. And also I would like to introduce our international speakers. Vice President of ICOMOS, Koran Gideon. I'd like to thank you for participating. Dmitry Davidov also is going to take part in our discussion. He is Chief Legal Officer from the Regional Association Westphalia-Lippe. Then Galina Malanicheva. She is President of the Central Council of the All Russia Society of Cultural and Historical Heritage Protection. Then we are going to have two more people from the Ministry of Culture, and also Vyacheslav Fatin, who is President of the Restorers and Conservators Union of Russia. Before we start this discussion, I'd like to say a couple of words, and this, I believe, would be important for our international colleagues, because we are going to discuss our local issues and problems. We all live here under the United Nations Convention, and as for a UNESCO organization, this year we are celebrating its 70th anniversary, and everything included into this convention is clear. But it is important to see what different methods of implementing this convention exist in Russia and Europe. We see such a great diversity in each country of Europe, for example. In many countries of Europe, there are federative laws, but also certain local responsibilities. Then there are differences in terms of judicial practices. Russia has most strict legislation in the area of cultural heritage protection, because our laws have incorporated Soviet times laws, because at the time we didn't have private property and all issues were resolved through administrative mechanisms. Our basic law on protection of historical monuments was adopted in 1992. So it was founded on everything that had been done during previous periods. So our federal law, unlike all other European laws, regulates everything, even tiny details of this area. The local executive bodies, they do have certain powers, but they are minor in comparison with the federal power. Lots of entities of the Russian Federation have local laws on protection of cultural and historical heritage, but very often they repeat word for word the federal law. Our times change, and we are going to touch upon some macro issues. For example, normative documents in the area of cultural heritage protection were developed together with the property rights laws. And in many countries, property rights have a prevailing nature in terms of interests, because there are countries, and if you are an owner of a cultural protected building, if you can prove that it is in bad shape and you yourself cannot restore it, then law and court can take a decision that, okay, then in this case, this building can be demolished. Sometimes there is a time specified and an auction is organized, and if no one wants to buy it, then again this building is pulled down. In this country it is absolutely impossible, and the initial legislation was based on the priority of protection of all monuments, and so this law is above the property laws. And this wasn't questioned in the past because there was this social norm, the prevailing social norm incorporated into it. During the post-Soviet times, the attitude towards protected monuments was sometimes negative. Then, later, some part of the society realized and felt that something unfair was done in relation to owners of these properties, and very often lots of issues we face now. This is due to a certain mentality of people. So all people realize that yes, it is good to protect cultural heritage, and it is bad to lose anything of it. It's not something conservative, but it is a sort of a neophobia. Okay, people get used to the existing environment, and all changes, even reasonable and sensible changes, are opposed. And in such a situation, during the first decade of this century, there was a consolidated opinion between the law and the society. But recently, we have noticed a certain division of these opinions, because we have overcome lots of syndromes of the post-Soviet era, and everything is more or less normalized in the property rights sphere. And due to certain social changes and shifts, there is some internal conflict in the society. So there is a certain negative attitude of middle income people or low income people, and so they are in opposition to those who have enough opportunities and funds to own and operate various expensive buildings in central parts of the city. And developers nowadays are viewed generally as some greedy people having no principles. These are terrible people who only want to demolish some old beautiful building and build something new in its place. If you compare what now people write about these developers in the media, it is similar to what people were writing about first business people in the 20s of the 20th century. So now this problem is not only of a legal nature, but it is also a political issue. And very often there are certain expectations of the society, and there's a certain mismatch with stereotypes. So the legal model is obvious, straightforward, and at the same time, it is sometimes misunderstood due to these differences in mentality I try to outline. We had a survey in Moscow, and we checked what is the opinion of the population. We asked them, are you for the protected monuments? They said, yes, we want to protect it. And then we asked, can you give us the name? Can you give us the name of at least one Moscow architect? And everyone gave just one name of Rastrelli, who actually worked not in Moscow, but in St. Petersburg. So in our society, this love for cultural heritage is something emotional, is something related to our mentality and culture, but not to the legal sphere. Not many people really understand, okay, who was Rastrelli, who was Kazakov, Bazhenov. These are great Russian architects, and we need to understand it. So when we discuss legal issues, we cannot we cannot only stay in this legal sphere, but we need to consider all these social aspects as well. So this is an important issue to be taken into account. And there's one more thing. Many European countries have already been through the process of subdivision of federal property and municipal property. And in many European countries, this was finished long time ago. We are still completing this. And this process actually initiated another process. We hear that the property committees, their position is quite strong, and they they are in a certain opposition to these cultural heritage protection laws, because there's a clash with property rights legislation. And we see that there are litigations, and now we are actually working at the front. So we fight for this. So we see these fights in our courts. And it is a fight between the right to property and then the 44th article of our Constitution, which stipulates protection of the cultural heritage. And since there are no direct definitions which norm is prevailing, here we see there's a clash causing all these difficulties. Then there's this eternal discussion of comparison of our cultural heritage legislation and construction laws. Then there are economic problems. For example, various discounts and tax exemptions to various development projects with international participation. Again, it sometimes is in conflict with cultural protection issues. And here we see that there are all these contradictions. And there's one more issue which should be somehow regulated. Otherwise, we are going to see more lawsuits every year. And sometimes we know that different courts take different decisions for similar cases. Russia doesn't have a precedent law system, and there's not enough practice here. And a lot will depend how we are going to change it, to adjust these mechanisms, and how we are going to understand each other. So all these issues are most relevant because in January, adjustments to the cultural heritage law became effective, and actually it's a new version of this law, and there have been heated debates, and definitely such serious amendments to this law, they cause certain difficulties because it's not quite clear how to implement certain new norms. And in this situation, it is most important for regional municipal bodies of cultural protection and the Ministry of Culture and various public associations. We need to understand all these new norms that became effective. There's another point, and we need to be open about it. When there are certain constraints and limitations, especially if we don't understand how we should deal with these constraints and how they can be removed, this very often leads not only to well-intended things and outcomes, but also something which is quite distant from the original intentions of those lawmakers. I represent Moscow. I don't know what the situation is in St. Petersburg, but we have already seen cases when some monuments were raided, when people under the slogan that they want to protect historical buildings and to protect the old Moscow, but actually they wanted to extort money from investors. And then these investors are promised that everything will be fine in the future. Why I have been speaking a lot about this public opinion and social opinions as for protection of historical monuments. We had only one negative case when this monument was pulled down, and now the police is investigating it. At the same time, a lot has been said that everything is bad in this sphere, but this relates not to the buildings with official status of a monument of historical heritage, but about any building. Some people say, no, don't touch it. It should be protected. It should be preserved. It should remain unchanged. If the society stands on this position, then we are a little bit tired of saying, excuse us, this is not a protected building, and but people are against it. So what shall we do? Shall we name every building a protected building, whether it is some wooden barn, some old wooden barn, or Basil's cathedral, the central square of Moscow? So there's a big question mark. And we have a lot of journalists among us here today. We cannot ignore such a function as a popularization of a cultural heritage. This is one of our functions. And here we see that not always we see objective description of certain processes. For example, in Moscow, we have completed restoration of dozens of unique buildings, and the billions of investments were used for that, and very often those were buildings in really bad shape, and you won't be able to find information about it because the media is not interested in these positive, good cases. Only some specialized publications cover this. I'm a deputy chairman of the Committee on Demolition of Buildings, and we managed to protect almost 200 buildings in Moscow. And without our work, at least 1/3 would have been destroyed. And some of these buildings are now recognized as cultural heritage buildings, but you won't be able to find information about it. At the same time, there are some singular negative cases, and then they are presented and distorted in the media. And if you read only that, you would imagine that, oh, everything is so bad in this sphere. And because for the society, all this is in their hearts at the level of emotions. They have this incorrect opinion. So they believe that, oh, our cultural heritage is being destroyed. And that is why when we adopt certain norms and when we discuss legal aspects, we shouldn't discuss whether we like it or we don't like it. We cannot influence the media. Of course, I understand that negative things are easier to work with for journalists. But at the same time, we need to understand that when certain decisions are taken, and if we don't explain, if we do not provide enough explanations to the people why certain norms are adapted, and of course we shouldn't describe them using legal language. Looking at various comments people write about new amendments, I see that they don't understand, really. But then all this is copied and reposted, and there are these strange negative discussions. So sorry for this long introductory speech. In conclusion, I would like to say that all issues in the area of cultural heritage protection, all this is outside the law sphere. And now, when we are introducing new norms and when we are incorporating them and implement them in actual life, we need to take into account all these social aspects. And I'm absolutely sure, and with my colleagues, we agree on that, and I hope that this discussion in this federal level cultural heritage monument, which has been refurbished, and lots of people during implementation of this process and project, people were saying, oh, this is terrible, this would be ugly, but you see the outcome is not that bad, and there's now a consolidated opinion about this group of buildings, the Hermitage. But I hope that through this discussion we will manage to find some common ground, and it will help both regions and federal bodies to work better.
So with this, I'm happy to give the floor to our next speaker, who is Mr. Gideon Koren, the Vice President of ICOMOS. And he has for us an extremely interesting presentation touching upon the basic document, which is the guidelines for all the countries in their protection of cultural heritage, which can be interpreted in many different ways. So for us, it's a great honor to host such an international authority of international law application and enforcement. Dr. Koren, thank you very much, and the floor is yours, please.
Thank you, Chair. I'm speaking in English, unfortunately. My Russian is not non-existent, so if you are not familiar with English, as I'm not familiar with Russian, please use the translation. Thank you, Chair, for your opening remarks. I would I was asked to present to you some aspects from the international level on the way the world is treating World Heritage sites, which is of course usually related to as the crème de la crème of the heritage preservation sites. And I'm very happy about this opening remarks made because as you will see, even when from my presentation, even if we speak about World Heritage sites, the world doesn't have a unified attitude how to deal with the sites, and let alone when we come to the protection of cultural heritage sites at the national level. Of course, things become more complex because legislation is different, cultures are different, legal systems are different, constitutional structures are different, and it's very difficult to find common denominations. So despite the fact that I will give you an international perspective, I think that this is a very important discussion because, as I will demonstrate to you, there is no unified international attitude to the preservation of cultural sites, not even the world cultural heritage, and so it raises, of course, many more questions when it comes to the protection of local heritage sites. I was very interested in the example you gave about the asking the people what they think about heritage preservation. And before I go to my presentation, I would just like to remind one issue which I think is very symbolic. I teach in many universities heritage preservation laws, and it is my habit in the first lesson to come to the students and tell them a hypothetical story in which I tell them that I have a building which is very significant, very important, very with lots of architectural values. I privately own it. I understand heritage is very important, but I have no idea what to do. This is, of course, a hypothetical example. And I ask the students to advise to me what are the list of issues they would like me to do with my building in order to protect it, because I'm enthusiastic about heritage, but I'm not a professional. I don't know what to do. So within 20 minutes, the students usually come with a very long list. And the list includes that I cannot destroy it, I cannot change it, I cannot reconstruct it, I need to conserve it. There are all kinds of limits on how I have to adjust the different systems to the protection, how I should use the same materials, what I can do with the building. Can I change it to a restaurant, for example? The usage, of course, is very important. And within 15 or 20 minutes, I have a very long list of all the things I must do in order to protect this very important building, which I own. And then I go to the second stage of the presentation, and I ask the students to think for 5 minutes about their own home, the home that they own, or the home that their parents own, and to tell me which of these things on the list they would be willing to voluntarily undertake to do with their own personal building. And of course, this is a different answer. And I think this is because when it comes to their own property, and when they are not hypothetically enthusiastic about it, as I present first of all, of course, they agree to nothing. They don't want to undertake voluntarily all these obligations. So this is something we have to remember, that whenever we deal with heritage, whether it's world heritage, national heritage, local heritage, this is always, first of all, an economical issue and not a legal one. It's a question of costs, it's a question of incentives, it's a question related to the financial aspects of actually dealing with preservation. And this is something we need to remember, because my presentation, of course, will also be about the legal aspects, but we have to remember that legal is only one aspect of heritage preservation, and actually, in my opinion, the economics of preservation are much more significant and much more important and much more problematic when we come to heritage preservation. So this is the initial remark, and I will go to the presentation about the World Heritage Convention and its impact on the legal protection of cultural heritage. So when we speak about the conventions, first of all, we have to know, even if we are not jurists, we have to know a little bit about the types of convention. It is customary to distinguish in the international conventions between three types of convention: constitutive conventions, declaratory conventions, and constitutive conventions which are recognized by international organizations, which is quite a more modern category. What are the main differences between the types of convention? When we speak of a constitutive convention, basically it is a convention which is only binding the state parties to the convention, the parties which decided to become members of the convention, parties to the convention. So it's a voluntary process. A country has to decide that it wants to join the convention. If it doesn't want to join the convention, it is not part of that convention. The declaratory conventions are considered to be binding all the states, even if they are not state parties to the convention, and a breach of a declaratory convention may lead to sanctions on all states, even if they are not parties to the convention. And that fact led to the so-called third category, which is a constitutive convention, which means you have to join it voluntarily, but it may also bind you or lead to some sanctions at the international arena if you violate such a convention, and it is recognized by international institutions, such, for example, as the International Court of Justice. Our convention, so to speak, in its full name, the Convention Concerning the Protection of the World Cultural and Natural Heritage, this is the full name. I will refer to it as the World Heritage Convention because I don't have enough time to mention the full name all the time, is basically a constitutive convention, as it is stated in Section 3 of the convention, which means that state parties have to join the convention, and consequently the sanctions could only be imposed upon state parties to the convention. And the potential sanctions are also deriving from the convention itself and carried out by the World Heritage Committee of UNESCO, which is the body in charge of the implementation of the World Heritage Convention according to its own rules. Now, what does the protection under the World Heritage Convention provide? First of all, before answering the question, I have to say one thing that the convention does not provide, and this is money. When we spoke about the financial implications of heritage protection, if we have theoretically two sites, one is a World Heritage site and the other is not, the world, UNESCO, ICOMOS, other organizations, and even the state parties are under no obligation to provide financial resources to World Heritage sites. So the fact that a site becomes a World Heritage site does not grant it any financial resources, not for the protection of the site, not for the management of the site, not for any other aspect of the site, which for some World Heritage site is a problem. It may have a touristic impact. There is a lot of research which says that if you are a World Heritage site, then from the tourism point of view and from the financial points of view related to tourism, the site, the town, the place will benefit, but there are no direct incentives. So what does the convention provide? Mainly, what I would like to deal with, because this is the relation between the international arena and the national arena, is Section 5 of the convention. We don't have the time to cover it, so I highlighted a few points which in my opinion are very important. Countries which join the convention are obliged, first of all, to adopt a general policy about cultural protection. They should have one or more services. Services meaning authorities. It can be a government ministry, it can be an authority, it can be an institution, but some kind of a service which will be in charge of the protection, conservation and presentation of the cultural heritage with the financial means and appropriate staff. There need to be some kind of scientific and technical operating method for such a site, also capable of counteracting the dangers which a site may face. And the most important thing is to take the appropriate legal, this is what we are dealing with, legal, scientific, technical, administrative and financial measures necessary for the identification, protection, conservation, presentation and rehabilitation of this heritage or heritage sites. So when you become a member of a state party to the World Heritage Convention, according to Section 5, a country must do a number of things. The main ways of implementing the convention is that each state party will create its own mechanism for protection. This is because the convention realizes that we have, as I said before, different constitutional and legal structures in different countries, so you cannot ask all the countries to deal with it in the same way. So this is why each member, each state party needs to create its own mechanism of protection, not necessarily similar to a different country's mechanism. And this is very important because though we are asking that the mechanism will be, the sites will be protected through law and also through the establishment of national institutions which will have the authority to realize the convention objectives. On one hand, we have the standard. We ask the countries to do something, to legislate and to have national authorities and institutions in charge of World Heritage sites. But on the other hand, we have the flexibility. We allow the countries to develop these laws and to develop these mechanisms and open these national institutions according to their own structure. And we have to realize that by saying that we have this flexibility, that by saying that we allow different countries to legislate different laws and to open up or to establish different national institutions, by this we are prima facie admitting that we will not have an international standard, that the standards will be national, that the laws will be national, that the institutions will be national, and so on and so forth. So we can see something which will be legally protected in one country, and under the same circumstances it may not be legally protected in another country. We may have a national authority or institution in charge of a certain site in one country. In another country, the same sort of site will have no institution because the system is having a different definition. I would like very shortly to demonstrate some of these changes in the way the convention is implemented. Some state parties have integrated the World Heritage Convention as is into their own laws, which means that the language of the International World Heritage Convention is also a state law. The main examples are Romania and South Africa, where the law is really identical to the World Heritage Convention. So everything the convention says is also a national law, but this exists only in very few countries. Other countries have created specific laws which deal directly with the protection of World Heritage sites. Again, we have many laws in many countries dealing with the protection of heritage in general. I'm mentioning the countries which have indicated some attitude to the protection of World Heritage sites in their law, which means that their law identify a special status for World Heritage sites, not just national sites. So we have a few laws like this. I gave examples from Australia, from Italy, and from the United States. And some states have established institutions to ensure the protection of World Heritage Sites. Here there is not necessarily a definition, a separate definition of World Heritage in the legislation, but there are institutions which are in charge of protecting the World Heritage Sites. And again, I gave a few examples from England, Mexico, Russia, Switzerland. And what we have to realize is that I gave the main examples. Many countries have not yet decided on the way to implement the convention according to Section 5. Now, these are, so far I had the good news about what has been done, what can be done, and what some countries already implemented. But there are some legal gaps and some things which the convention unfortunately faces still many difficulties that still exist, and the protection, and hence the protection provided by the convention is not sufficient. I would like to demonstrate the main gaps. First problem, we have to remember, as I said, the nature of the convention. Many state parties are not party to the World Heritage Convention, and consequently, these states are not committed to the provisions of the convention. We still have many countries which are not party to the convention at all. The second problem is that a site will be inscribed as a World Heritage Site only if the state party requests it from the UNESCO World Heritage Committee. The parties to the convention are the states. So we don't have a scientific a way of identifying the World Heritage sites. It is for the state party to decide that it wants a site to be included as a World Heritage Site. So we may have a very important site in a country. If that country does not submit a proposal to include it in the World Heritage List, it will not become a World Heritage List. So that's a second issue. As I mentioned before, some countries are still not implementing Section 5 of the convention, and basically never established legal procedures or services to ensure the World Heritage protection. By the way, even today, and we are now more than 40 years after the convention was signed, the majority of state parties have not yet reported to UNESCO how they decided to implement Section 5 of the convention. And this is a very important fact. Problem number 4, which unfortunately is very much demonstrated in the recent months, is that some sites are facing increased risks, but they are under the control of independent hostile organizations, hostile to heritage for sure, as we see the situations in Syria, Iraq, and other places in the world nowadays. And of course, when we deal with such organizations or such groups of people, the convention has no mechanism of dealing with the risks that the sites face. And last but not least, the convention provides only one solution for a breach of its provision. Even if we have a state party, we have a World Heritage Site, and there is a breach of the provisions of the convention, the only sanction that we have is a removal of a site from the UNESCO World Heritage list. The famous last example was of the Elbe Valley in Dresden. In Dresden, there was a procedure that took a few years, by which the UNESCO World Heritage Committee announced that building this new bridge will endanger the World Heritage site, and after the local authorities decided that they are going to have the bridge anyways and ignored the international warning, the UNESCO World Heritage Committee decided to remove the Dresden Elbe Valley from the World Heritage list, which is a result of the local council insisting on building this 4-lane bridge. But of course, we have also to recall that the result of this sanction are opposite to the convention objectives. The removal of a cultural heritage site from the list is maybe a punishment to the country or a punishment to the local authority, but as far as the protection of the site, it doesn't do the site any good if it is not on the list anymore. It is not protected in the same level anymore. So the World Heritage Site itself does not benefit from the removal of the recognition from the list. Another way that you should be aware of, which is aimed to cope with the local protection, is the World Heritage Committee operational guidelines, especially section 97 of the operational guidelines, which asks that each nominated property, before it's inscribed as World Heritage, is going to have a management plan which will include the description of the legal protection of the proposed site. In the past, in the first years, sites have been inscribed as World Heritage sites despite of lacking a sufficient management plan. But nowadays, the ICOMOS policy, ICOMOS is, for those of you who do not know, ICOMOS, International Council of Monuments and Sites, is an NGO, is an international professional organization, which I'm the vice president of, and it is one of the 3 organizations advising the World Heritage Committee of UNESCO on the inscription of World Heritage sites. So once a state nominates a site, it goes to be, it is reviewed by these 3 organizations, and they provide UNESCO with the recommendations as to whether to inscribe the site or not. And it is the ICOMOS policy nowadays to advise against the inscription of a World Heritage site when a state party does not demonstrate in its proposal that it has a sufficient and an adequate proper management plan for the site. And a management plan, of course, includes the legal protection. And so the ICOMOS practice is very beneficial for the protection of the World Heritage Site. However, the World Heritage Committee, the UNESCO World Heritage Committee, has not always adopted the ICOMOS recommendations because of various reasons. So we see that we still face a few issues, and I didn't want just to present you the problems, but also maybe some solutions. And we have a few suggested solutions that we can discuss in the course of the day. First of all, the first solution is to increase the authority of the convention by changing the statutes of the convention into a constitutive convention, meaning that it will be recognized by international organizations. This will enact the adoption of several potential sanctions on a state party which does not respect the provisions of the convention. This is not the status today. As I said before, the only sanction is to remove the site from the World Heritage list. However, if we consider the convention to be very important, we may sort of upgrade and increase the authority of the convention. Secondly, we can ask more, I would say, actively for the reinforcement of the application of Section 5 of the Convention. As I said, the majority of the countries have not decided yet how to implement it. And we can also sanction the countries which are not implementing by not enabling them to inscribe sites on the World Heritage List before they decide on the ways to implement Section 5. This is, of course, a decision that UNESCO has to take and has not taken so far. Thirdly, it is possible for the UNESCO World Heritage Committee to adopt a policy similar to the one of ICOMOS, so that a state party which will not provide a proper management plan with adequate legal protection to a proposed World Heritage Site will see its request refused. This is actually the last chance, so to speak, to enforce a competent legal protection, because after the site is inscribed, there is, as I demonstrated, very little we can do. So to conclude, I think that there are, at the international arena, as we could have seen, some very positive means which have already been developed. There are still legal gaps which are still identified and needs to cope with. And I also hope that I was able to demonstrate to you some of the possible solutions that exist. Thank you.
Большое спасибо за очень интересный.
Thank you very much for this most interesting presentation. The position of ICOMOS, we see, is progressing towards a strengthening of the actual mechanisms used for those who violate cultural heritage protection norms. And this is typical not only for ICOMOS, but also for various country level bodies, because when we travel, I always ask a question: what do you do when someone violates a cultural protection heritage law? I hear that sometimes people say, oh, we try to convince them not to do it. So, and what you are describing, when there's actually no special penalties or ways to stop these people from violating the law. We have included here in Russia certain administrative measures, and there are, for example, serious fines and penalties for those who do this, and this is a way to move towards a more efficient protection. And of course these punitive measures, they should prevent people from even trying to violate it. So thank you for the information you shared with us. And I remember there's a funny case. There's a building, and two people living in this building. You know, they both installed some new frames and the air conditioner, and they both did it. And they say they send letters to the protection bodies saying, "Oh, you see, that guy is wrong, so and you should remove his air conditioner." At the same time, they don't want to remove their own. So there's no discipline, as we see, and there should be something that can be done against it. Dear colleagues, how should we structure it? What about questions to the speaker? Shall we do it right after the presentation or maybe later? Okay, if there's a... So let's maybe hear one or two questions right after each presentation, and later, maybe during a coffee break or after this session, you will have a chance to discuss it personally. Right, our next speaker is Sergei Mirzoyan, who is going to tell us about this new act. And I would like to ask Sergei Mikhailovich to follow the time frame. So this is the International Legal Forum, and everything we are going to discuss here can be included into the minutes of this roundtable, and later these minutes can be sent to the Ministry of Law. So could you please, being deputy head of Mosgornasledia, to give us some formal overview. Thank you very much for this opportunity to describe this area of cultural heritage protection from the legal perspective. The previous speaker was absolutely right in saying that national jurisdictions are quite free and flexible in terms of regulating these rights. We have a very good law on cultural heritage protection, At the beginning of this year, it has been amended quite seriously. Actually, now we have an absolutely new version of the law, and I would like to touch upon some major changes. And I would like to draw your attention to the importance of these amendments. And also, of course, it is important to continue this work of enhancing our legislation in this area. This is a legal forum, and actually all these discussions are aiming at improvement of the existing system. We have heard already several times that the Russian laws provide a serious mechanism of legal protection. And really, when we communicate with our international colleagues, we hear that not always at the national level they do not have certain requirements, for example, special law decisions to take a certain building away from the owner if this owner violates the law. So in some countries these requirements do not exist, but we do have it, and recently we succeeded in taking away from 3 persons who were owners of a historical heritage building. So they were doing nothing to protect this building, and now there will be an auction, and this building will find new owners. So it is possible through a court order to take also a land plot away from the owner if the owner has destroyed or can be blamed for destruction of a cultural heritage building which existed on this land plot. In the law, we have a provision that this land plot can be confiscated as a sanction for the offense. Or so this definition comes from the first decade of this century. This definition was not in line with the criminal law which exists nowadays. So this term sanction, so the criminal law, administrative law, does not include such sanctions. Sanction in this case is a specific term of this type of actions. And in the past 5 years, this was the first time when a cultural building, a wooden building, was destroyed. It was cut into pieces, and now there's only a foundation that can be found there. So now we see that we have to deal with it, and there are legal problems. There's a criminal case, and the owner is saying, no, I didn't do it. Some other people, some unknown people did it. But it is obvious that they wanted to destroy this wooden structure in order to build something new on this land site. So such situations should be regulated more efficiently by law. Another case, this is of a more positive nature. In the Russian law, there is such a thing as a protection obligation document. It doesn't exist in international jurisdictions, but here it is one of the main documents regulating relations between owners or people having rights to operate some historical buildings, and the bodies, official bodies responsible for protecting the cultural heritage. This document includes all obligations of the owner. And this institution of this protection obligation has been developed and improved. So in the Soviet times, everything belonged to everybody, and the Cultural Heritage Committee was was issuing such obligations documents to other state authorities. So there was a certain agreement between the Cultural Protection Committee and some committee which was responsible for those works. And in those times, nowadays, we see that owners are trying to evade to sign this obligation. But now, in the law, there's a provision, and this model had been used in Moscow for some time. And we, at the local level, we regulated these relations, and now it is worked out. But there is another issue we came across. All right, there is this protection obligation issued, but then this document should be handed in to this owner, and only after the owner signs the notice that he has received it, only then they have to follow it. So we see that now they will try to avoid receiving this document, and we already came across it when we cannot find representatives of the legal entity which is an official owner or a title holder of this building. So we need to probably work with the registry, property registry, state property registry, and we were discussing it with this federal agency, whether we can find this. Can we do it? But there are problems. So we are trying to include this in encumbrance. Okay, but by law, again, only owners themselves have to apply to register it. So this registry body works only with owners, and rights are registered only at the initiative of the owners. So there's a clash again. Okay, another issue. This is about good norms that were incorporated, and this concerns areas or territories of the cultural heritage property. There are certain limitations or constraints for its use within this territory. But it is not yet clear how to register it and how they should be registered in the state cadastre. So on the one hand, this territory and the protected zone from the land properties list. This means that now we cannot commission any works for inclusion of this land plot into the cadastre. So the law is effective already, but there are no actual norms for doing this. So we expect that our federal colleagues, Ministry of Economic Development and the Ministry of Culture, because it is within their competence, so we hope that in the near future there will be clarification of this, and there will be some normative acts under this law. Then it will be possible in practice to implement these updated norms of the federal law. Next point. It should be noted that in the Russian law there are norms that regulate that land works on the territory and also on the land plot which is adjacent to the cultural heritage site. This construction and land works can be done only after cultural and heritage expert evaluation or expertise evaluation. And this is important for surveying this cultural environment. Okay, this is an obvious requirement, but it is not quite clear. For example, what is an adjacent land plot adjacent to the historical site? Because sometimes there are several land sites, or maybe this protected building occupies only part of this land plot. So it is not quite clear. So there should be some streamlining with land use legislation, and also there is another norm that this cultural expertise inspection should be done for those land plots if the Cultural Heritage Committee has no information whether there is a protected building or potentially protected building and so on. It means that absolutely all land plots where we are planning some work, we have to commission this survey, this evaluation. This means that for any land plot, you need to get this cultural heritage assessment report. So it means another link in this long chain that developers have to go through to get a permit. We'll see how this will be implemented in practice, but we need to trial this, and probably we need to communicate with federal agencies. How should we distinguish these lands and what should be included into this list? Another point I would like to stress, this is some new adjustment to the law. It is a new provision, but it is not clear how to implement it. So if there are some restoration or conservation works in a protected building, these works can be performed only by licensed specialists, licensed by the Ministry of Culture. The restoration and conservation works should be organized by such people or organizations. It is fine. But if you read it word for word, then it means that every person actually working on the site should be licensed, because in the law it is written that all work should be performed by licensed specialists. So we are not ready for this. Why not? Because we checked the statistics. It is for the 19th of May this year. About 380 people are licensed in Moscow. In St. Petersburg, 163 people have such licenses. And if we put these numbers together, okay, this will be actually 60% of all all people who have these licenses in the whole country. So you can imagine how many of these specialists work in other towns. So this norm should be either clarified or we need to extend this work, and more specialists should obtain such licenses. And this concerns not only some actual works, restoration works, but also design works for restoration as well. In the law, all works are included. Then there's another important item, and it has been mentioned already today. It is the cultural protection laws and urban planning laws. And there was an attempt to improve it in this updated law, but when we analyzed it in detail, we realized that further work is needed. What happened? For a long time in our urban planning legislation, you probably know, there was only state expertise evaluation for cultural heritage monuments. And we have also historical and cultural heritage evaluation right now. And there was a ban for all sorts of expertise evaluation apart from the design packages. So now there is no discrepancy in the law, but there is another provision that apart from state expertise, so right now we see that it is not quite clear at what point we have to get an approval of design packaging with the cultural heritage protection bodies. Yeah, this is anecdotal, but this state expertise evaluation is necessary for justification, expert justification of the decision taken by the cultural heritage body for a specific project. And when this urban planning law includes this requirement for cultural and heritage expertise evaluation, this is one thing, but there should be this approval, formal approval by the body responsible for cultural heritage protection. And when we were preparing for this forum and we were communicating with the Ministry of Construction and Ministry of Culture, we were asking for clarifications, and actually we received absolutely different answers, because if the Ministry of Culture has some reasonable expectation that yes, this package should be sent for this approval, and the Ministry of Construction said that this is against the federal law and there shouldn't be any approval of the documents prior to the expertise evaluation. So we see that these quite different opinions of state bodies. We need to clarify this provision of the law.
Now, I would like to very briefly dwell upon another block of subject, not related to the previous ones, but rather related to the issues of investments into listed sites and their protection. For a long time, the federal legislation had no proper regulations for involving regulators into historical site protection. In Moscow, we initiated a successful program called 1 ruble per 1 square meter. So what does it mean? You probably know that the program provides for auction sale or public sale of sites that are in inadequate condition. And once the sale is announced, the site or the building shall be sold at market price. And then the winner shall restore the building or structure. Then it submits the results to my department, and then they can ask the property department for a lower lease rate down to 1 ruble per square meter. So this tool, this mechanism, has been successfully used in Moscow, and now it's adopted by the federal ministry and the federal law. But it was slightly changed. That's why we now have some problems in using the federal law inside the city of Moscow. So according to the Moscow model, first the sale starts with the market price, and then the rate is converted to that famous 1 ruble. But under the federal law, they start with that 1 ruble per square meter, and then there is a competition of the bidders, and the price goes up. And then, even if the site or the building is adequately restored, the rate will not go down. We believe this is a wrong thing to do. In some regions, it may work. In Moscow, this raising rate simply does not work. It's not up to the expectations. So we believe that we must go on improving the regulations and the legal provisions for properly structuring public sales of sites and buildings to be restored, to properly balance the interests of all the stakeholders, and the legislation should eventually be drafted in such a way that it could work in all the sub-federal territories. I would now like to tell you about a slightly different model, which is now announced by the Ministry of Culture. The name of the program is the Green Channel, or the Green Band, or the Green Corridor. That's when heritage sites in poor condition are privatized and become part of the charter capital of a joint stock company. And this joint stock company shall be 100% owned by the state. And then the managing director, the managing directorate shall draft all the relevant documents to support the site, and the site or the building goes into public sale, and a prerequisite of that is transfer of the right of property to the new owner after the complete set of restoration and renovation works is completed, and the Acceptance Act is signed by the relevant Heritage Protection Authority. The authority is the technical client. That's an official function. And it also is in charge of obtaining most of the permits as per the current legislation. We believe that this is yet another quite interesting model, and it should be tested and piloted. We know that it has been used. We do not know what is the demand for this model of protection and restoration is. We do not know that yet, but the more protected sites are involved in economic turnover, the better, of course. We need to understand that not a single sub-federal territory can financially support these activities, especially given the economic recession. I mean the activities of supporting, restoring and maintaining all the protected sites needing restoration, because there may be a great number of such sites in a sub-federal territory. So we need the diversity of the models, and we need to take advantage of all the possible tools. We need to bring down as many administrative barriers as possible, especially what regards funding the restoration of protected sites and getting them involved into the local economic life or federal economic life. The more we succeed, the more sites and buildings we shall enjoy. Thank you very much. Thank you, Mr. Mirzayan. Of course, Sergei has only indicated some basic issues. With regard to this draft law, or rather a law, it's a law in force right now. I still have a lot of pending issues. I fully support what Mr. Mirzayan is saying. We believe that this federal level attempt to do everything at the federal level has not been successful. There are so many gaps at the stage of proceeding to the practical operations of the system. It is difficult to figure out who has to file what applications and who has to obtain which permits. Not everything has been prescribed in the draft, so we don't have all the necessary provisions in the law. Okay, the city has the Department for Protection of Cultural Heritage, and there are the executive authorities that can be tasked with it. But now a sub-federal entity has to carry out about 100 competences and issue 143 types of documents, all kinds of approvals, permits and agreements. This is very difficult to organize, even at a federal level, and at the regional level they simply don't have enough staffing of the relevant departments. As Mr. Mirzayan has said, when we introduce new regulations, we have to prioritize, but the property departments and the cadastre institutes oppose what we do, because for us they have other legal priorities. There are different legal priorities between them and us. We seem to generate problems. So there is still a lot of work to do with the legislators. Also, as we have discussed with Mr. Mirzayan, let me make something very clear for our regional colleagues and for our Western colleagues. All the protection efforts are the tasks and the responsibility of the regional authorities, with the only exception of the UNESCO-listed sites. There are 3 of them in Moscow: the Kremlin, the Kolominsky Church, and the Novodevichy Monastery. But thousands of other sites are within the jurisdiction of the municipal authorities. In this situation, we must understand that a lot of authority is delegated to the regional or municipal level. Remember, I've mentioned 143 documents. Half of them are new to us. So we don't really understand the format. We're not sure we're interpreting the law correctly. I can't imagine how all this can be interpreted into a foreign language for our foreign colleagues. We're all lawyers, and we don't have any clarity with regard to legal definitions and wording of the regulations. So this is the situation. If there is no clarity in the regulations, wording and definitions, how can we be clear when we talk to people? We keep asking for interpretation from our colleagues in the ministry, and they tell us it says regional, so you figure it out at the regional level. But one region gives it one interpretation and another regional authority gives it another interpretation. So how can we talk about a single single heritage protected system at the level of in the scope of the whole country. Dear colleagues, please make a special note of this. The Council of the Federation and the State Duma promised to us that they will not abandon us with the interpretation of all those new legal provisions. We are not coping. I would like our colleagues from the Federal Center to provide clarification so that the same provisions could be identically interpreted and implemented by all the regional and municipal authorities. Like I have a cross-section of the city of Moscow, Moscow region and Kaluga region, and we may have discrepancies in interpretation of the federal legislation on heritage protection. What are we supposed to do with this? We need to understand that the federal law will be amended further and further. It's going to be a long and difficult process, and we need very active participation from the Ministry of Justice. I'm sorry for being so emotional, and the information sounds a bit chaotic, but this is because we have so many discrepancies, so many gaps. I believe that the Department of Heritage Protection might want to address the military authorities so that they could help us chase the site and buildings, the protected sites owners, because sometimes we can't find them. So we find one thing in the Constitution and we have another thing in the law. If the owner of a protected site is not notified, he seems to have no responsibility and no liability under the law. Why shall we draft all those requirements and provisions if we cannot apply them to the entities really responsible? Remember the process of streets remaining. Lots of streets got their historical names back, but in the technical documentation for municipal property, we still have a lot of old street names. So we take some protected building, some listed building of international significance, and it came under a litigation because we sued the owners of the building, and the court did not rejected the lawsuit because we had a discrepancy in the address, the old address versus the actual address. It's a documentary discrepancy, and we could get nowhere with that. That's what happens in real life. That's what happens in practice. We need to put in a great amount of effort so that all our beautiful legislatory and legal structures do not get drowned in the practical difficulties and red tape and bureaucracy. Again, I'm sorry for being so emotional, but I really am very emotional about these practical difficulties. I think by now I could author a book of jokes on cultural heritage protection in this country. Private property cannot be owned by foreign citizens in Moscow. And one of the owners of a listed building, as we have found out, is a citizen of the Republic of Chad. And there are all the documents. He has a legitimate right to own a listed building, being a resident and a citizen of the Republic of Chad, without ever coming into the country. He has never been in Russia, that owner. So and we can only sue him for not properly protecting the site in the Republic of Chad, where he is domiciled. This is the law. What are we supposed to do about it? So we take one little piece of paper, and this little scrap of paper kills this whole beautifully structured legislatory system. Who are we deceiving. We are deceiving ourselves. Real people do not care whether we have the right scrap of paper or not. The citizens, the society, care about buildings, historical sites and cultural monuments to be properly protected and preserved. For the last 3 years, the investment into this area has been 50 billion rubles, and half of that is private investment. Investors are voting with their cash, as we say in Russian. And we used to have a whole chain of 26 actions to be taken to invest properly. Once it was dealt with, now it's much easier for the investors. And we don't want to get back to that chain of 26 approvals. There is a lot of inertia in this country. We need all the proper legislation and regulatory acts in place, of course. That is needed, but it should work, and it should work adequately. It's a shame to be saying all this at an international legal forum, but if we don't say it here, we might not have another chance. We need a law, but we need the historical heritage more than the law. The law is just a tool. We don't need any scholastic mechanisms. We need legislation that is in line with real life of today. Dear colleagues, I'm supposed to be a moderator, not a speaker, really. I apologize for this. Okay, haven't we agreed not to blame Law 315? Okay, we have a question and we're happy to take it. Sorry, the booth needs the question to be asked into the microphone, please. My question is something related to a sore spot in Moscow especially. It's about monument protection. I mean the monument to Vladimir in Vorobyovy Hills. Just a couple of words for our foreign colleagues. You probably know about the famous building of the Moscow State University. If you have been to Moscow, you know the panoramic viewing point right next to the university building. This is a signature spot for Moscow. It's very famous, it's very much loved. So when Count Vladimir's anniversary was marked, and Count Vladimir, or Prince Vladimir, is the prince who baptized Russia into Christianity. So once a decision was taken to make a monument to him, and the Moscow State Duma, the local authority, selected the site for this monument. So they decided to have the monument at this panoramic viewing point in Vorobyovy Hills. It is a bit strange because this is a place where the university is located. The site is associated with the idea of education, and the university building is a neoclassical building of the early 20th century. The famous Stalin high-rise buildings. They are a signatory set of buildings for Moscow. And the monument proposed, the statue proposed, is supposed to be 25 meters high, and it will obscure the view of the Moscow State University building. The site has 5 protection statuses. So how can this possibly be? There are all the letters from the Heritage Protection Department. They are starting to improve the site and prepare it for the future installation of the statue. How does that come in line with all the existing protection statuses? This is a natural protection area because the Vorobyovy Hills is a natural protection area. The architecture of the university is protected. Anyway, the site actually is a cluster of 5 overlapping protection sites. The construction or any excavation works are directly and explicitly prohibited in any one of those overlapping sites. How is it possible that they are starting to prepare the site for installation of the monument?
Dear colleagues, I asked you not to ask very specific questions. Okay, it's something very interesting to you. Okay, maybe in the break. So why are you addressing this question to me? Because I don't come from the Moscow government responsible for this area. Right, but I hear that this law is violated here. That's why I'm saying this. I'm not a prosecution attorney. You know, I cannot decide. But I would like to hear your opinion whether there are violations or not. Then you said at the beginning of this session that the opinion of the public should be taken into account. And I know that over 40,000 people who signed a petition against this monument. This is something. I'm an attorney myself. That's why I'm asking all this. Right. But this monument, the construction of it, was initiated by the Historical Society of Russia, and the State Duma voted for it, supported it, and I would like to bring us all back to the topic of this session, this forum, and I would like to give the floor to Mr. Davidov now. And as for your question, if you start asking questions about, thousands of questions important for Moscow and everywhere else, then we will spend all our time doing that. Okay, let's keep to the more general discussion. Thank you. My name is Alexander Maslov. I have a question to you, Alexander Vladimirovich. Please correct me if I'm wrong. You are saying that there should be some unified approach, whatever the region is, to the process of obtaining approvals of any works related to cultural heritage protection. And land works are actually subdivided. Some of them should be approved at the federal level or regional level. Maybe it will be good for regions to do it. Mr. Gideon told us that every country has their own legislation depending on the type of monuments they have. Well, we are not different countries. We are all parts of Russia, just one country. Nizhny Novgorod is quite a big town, but still, you're still part of this country. And Mr. Gideon was speaking about Europe. So my position is that whether it should be given to the regions. This is one approach, and the federal law actually has moved away from it. The federal law determined quite a vast number of procedures for federal significance protected buildings, but at the same time there are no unified mechanisms for this. Okay, if we take a certain decision tomorrow, for example, and we all in St. Petersburg, in Moscow, in Nizhny Novgorod, we start doing it and implementing it in practice, but then some inspectors may say, no, you were wrong because there's a different interpretation of this law. So in this situation when there's no clarity, I believe something should be done. I believe regions can can expand legislation, but regional laws right now, they simply copy the federal law. And very often lawmakers at the regional level, they don't understand what else can they do, what should they do if their legislation copies the federal law. So maybe there should be some clarification, some recommendations, some guidelines. For example, we have the so-called the Unified Museum Fund, and there are instructions for keeping museum exhibits, and there are no questions wherever you do it, in what region and so on. I believe here, in this area of protecting cultural heritage properties, there should be something similar, when everybody understands it in a similar way, because we are still part of one country. We have a constitutional law and we have federal laws, and we should operate within these. My name is Maria Alexandrova. I'm from the Civil Law Department of the Faculty of Law of St. Petersburg University. Here, I share this perception of this law, federal law. Sometimes when people from all over the country come to our faculty, we have conferences devoted to cultural heritage protection, but we hear that people working in the sphere in regions, they cannot understand this text, and we are actually in shock. For example, I have so many criticisms about this new text of the law, and the whole idea from moving from these civil agreements to public constraints and obligations. I have been speaking for about 15 years about this. Why do you believe that this idea that the owner of the buildings should sign that they have received this protection obligation document? In the civil law, now there's a norm. If some person does not receive letters at their address, it means nothing, so they're still informed. This is a legal perspective. Then another point, displaying or making public all of these protection obligations. For example, if in the cadastre there's this, if this information exists, very often people say, you have been informed because this thing was part of an open database. So you can use this mechanism as well. And in the future, so, please consult civil law specialists. There are real mistakes. So if one of the terms of the agreement hasn't been agreed on, that it means that the whole deal is void, and the practice will demonstrate that every every agreement signed in the past, it will become void. So a civil code should be consulted. There's a serious mistake, and also there's a law on registration, and also there's some retrospective requirement that there is a provision that all existing agreements and contracts should be revised and adjusted, and there's a transition period of 1 year for that. So some deals, they were concluded earlier in the past, and now they suggest in this law that some additional terms should be included. And what Sergei Mirzayan outlined, we supported adoption of this law, and actually at the time of its discussion, we informed about all our questions. And now we see that there are all these discrepancies. Okay, our colleagues have used our experience. That's fine, but But as for notification of the owners, okay, when they receive or sign for receiving certain document, yes, we have requirements that certain things are announced on the internet. But here we need to send notifications, for example, to owners of a building where there are 200 apartments and 200 owners. You know, can you imagine? We need to send so many letters. When I was very young, I worked for the post office, and people don't open the door, they don't want to receive it, and whatever is written in the norms, it stops there. People don't get it. And you know, for example, what about our army service? You know, so many people, you know, they don't receive their official notifications, and then you can do nothing in court. As for this official notification, in the law it is written from the moment of receipt of this document, you know, and this word receipt means that they should have received it. So this discrepancy in understanding of this and interpreting these norms. Okay, let's stop this discussion right now, and do you have a legal question, maybe last question before Mr. Davidov can start presenting his way? My name is Irina Goncharova. I'm from the Territorial Department of Municipal Property Committee in Smolensk. 1 year ago, we had a court decision, and it concerns a cultural heritage monument, and it is a monument to General Platov, who was a hero of the war with Napoleon. And we referred to one of the provisions of the Ministry of Culture, and that involved restoration of this monument. The owner of this monument, it is a federal property, and the court, according to the court decision, it was decided that this federal monument should be maintained and restored by the Federation. All right, we are not against it, but the majority of monuments belonging to the state, you know, so now we as a territorial body, we have to do it. There's so much work for it, and we realized that it would be problematic. You know, the Ministry of Culture didn't attend that meeting, so it was not interested in it. Now I would like to hear your opinion. So that this court decision confirmed that this should be the Federation, but the Federation means nothing. Okay, so what is your opinion about the situation? How can we protect such monuments in regions? We are not Moscow, we are not St. Petersburg, we are not so advanced in this area, and but still our region is very rich in monuments. We have this fortification walls, quite famous, and so on. So who will be the holder of these protection obligations? Is the Federation going to sign this obligation with itself? So because both parties, those responsible for protection and those who need to perform all these works, so the same party. And some people, you know, they fall off these fortification walls sometimes, and some people even died after that. Who should be responsible? What is your opinion? Okay, it is clear that there will be lawsuits, and we will hear what will be the result of these litigations. But okay, as I see it, I see there are two problems in it. First of all, you are speaking about these walls and towers, you know, the monuments to people. You know, you cannot sell it, you cannot find an owner for it. In Moscow, we have hundreds of such monuments, statues to people, but they are not on the balance sheets. This is not a movable. It's not movable. So, for example, the monument to Pushkin was registered only because there was a court decision on it. So this has been revised. So now in the law it is movable properties and other monuments. So these statues, they were not registered in the cadastre, so you cannot find anyone who will be protecting it. And you know, as for that monument to Pushkin, it is the central square of Moscow, and you know, there's this thick metal chain around it, and you know, 3 times they were stolen. We don't know, maybe they will be stolen again. And we were trying to find out who should be responsible for this. And as for these public area monuments, counties of Moscow, Moscow boroughs, they are responsible for that. In St. Petersburg, they have a different system. There's a specialized organization dealing with them, but this is within cities. But if there are vast territories, we don't know. As for the federal budget, they will say, it is your property on your territory, and you need to find someone who will be maintaining it. Okay, we have agreements with various military bases and educational organizations, and very often these organizations say, okay, that's fine, we are ready to protect it, but we don't have money for it. Okay, there was another case. One federal educational organization, they showed that they send applications 4 times so that they get money for restoring a certain monument. So they don't have money, and they get money from the federal budget. Okay, there was a law litigation, and we requested through this court decision the Ministry of Culture to provide money for that. And what was the answer? No, our claim was not satisfied, because the court wrote in its decision that these are federal budget issues and they cannot interfere in this budget process. So there is a requirement in the law that there should be budget funds allocated for such functions, but the court cannot influence this. Unfortunately, this model that could have worked in this case, and the ministries could have been supported in this. So our ministries, they could demonstrate to the Ministry of Finance, look, this obligation requires me to provide funding for this. Courts don't do it. And when we sent an appeal, the decision was, the topic is, yes, important, but we cannot do it. Can you send it to the next level? Maybe they will take up this responsibility. So this is a general. There was also a general problem outlined. What role should be played by the cultural protection bodies in terms of actual protection and maintaining? and the Ministry of Culture and various departments, they are supervising bodies. They do not actually perform any restoration works. They're responsible for the control over this implementation. That's why you lost probably an entity of the Russian Federation, the owner, a similar owner, like any other organization or person. They can transfer this function to another body, like it is in St. Petersburg and Moscow. But it is one of the key notions of the Russian law. So the restoration works should be vested in its owner, and in this case the Russian Federation is a similar owner. So your question is how this should be done. Definitely it is necessary as a property management body. You should take measures. You should distribute, you should allocate these monuments to different executive bodies. Buildings and monuments, they shouldn't remain in the exchequer. They shouldn't remain on your balance sheet, because then you will have to finance their maintenance. And as for other properties, not buildings, I believe in Moscow we have this interesting practical implementation. We in Moscow, we issued a decree at the level of Moscow, and we sort of distributed these monuments, these statues, among boroughs of Moscow, and it is clear who should be responsible. So this is again the balance sheet issue. So these boroughs of Moscow cannot include it into their balance sheet, because these monuments cannot be assessed, they cannot be included into the cadastre, because these are just statues. When we joined Moscow government in 2011, we provided financing for removing drug addicts and homeless people who were living in those historical monuments, and it was done together with police. So we were relocating, some strange people who were living and using those properties, and it was even dangerous for our specialists. And we did it. We cleared those sites, and a lot of people had offices in those buildings, and they used all public utilities, because on paper it was a vacant building. There was something strange. There were illegal hostels and whatever. So if you have a will, then you will manage to do it. But you cannot, start with only. You cannot start at the paper level. We in Moscow, through this will, we managed to do it. I know that at the federal level, there's no mechanism for this. So it's hard to use this will. We in Moscow, only central district has all these monuments and statues, but in the Smolensk region, I don't know if you have vast territories, I don't know, but probably some solution can be found.
We have a mixed approach to resolving these issues in St. Petersburg. We have the Museum of Urban Sculpture, and they have an office in charge of maintenance and restoration and protection of historical sites and assets. Of course, they are trying to fight off any new sites to be put in their charge, because they have limited resources, of course. But there is a governmental resolution under which the municipal administrations and local authorities are in charge of maintaining the listed buildings and sites, and they are short of funding for those efforts, of course. But at least the legislation covering this activity is in force and it exists. If there are no proper financing efforts made, the whole work, of course, will be ruined. Thank you for your questions, and we still have one presenter to go before the coffee break. And we have a presentation by Mr. Davidov, the Chief Legal Officer from the Regional Association of Rhine-Westphalia, Mr. Dmitry Davidov. Dear colleagues, esteemed ladies and gentlemen, do I really have 20 minutes, or what's the real time limit right now? It's as per the agenda. We cannot cut your time. We just can't. Thank you. All right. Let me draw your attention to some legal tools and procedures for historical sites protection in Germany. Let me start with the separation of liabilities or discrimination of liabilities. As is different from the Russian Federation, in Germany there is no federal law on heritage protection nor any federal bodies to take care of this. The whole area of culture and all the culture-related legislation exists at the federal lands or federal states level, with the only exclusion. We have a federal law on combating cultural heritage leaving the country, but that only regulates movable cultural values, and only the cultural values that are part of a special list of cultural heritage assets. And again, the law only covers exports of such assets. Otherwise, we have 16 federal land laws on heritage protection. Some provisions of these laws are very similar, but there are also some fundamental differences. Now, with regard to the structure of administrating the cultural heritage protection and preservation, in virtually all the federal lands, the structure involves separation into two different branches. On the one hand, it's the bodies for heritage protection, and they are executive bodies, in fact. On the other hand, there are specialized expert bodies that are in charge of preservation of the heritage assets. The first category belongs normally to municipal or district levels, and they issue permits for maintenance or repairs. They issue orders for restoration works. Also, they apply administrative sanctions if any laws are broken with regard to heritage protection. But now the expert specialized agencies belong to the regional level, and their competences include identifying heritage sites, studying them, popularizing them, drafting methodologies for their protection, doing excavation and archaeological works and studies, and also doing historical and cultural expert assessment for all the sites. According to the results of those assessments, the site may or may not be included into the protected assets list. Also, that will be the basis for restoration works if needed, and the historical and cultural expert assessment outputs are also used for urban development purposes. The federal land laws also regulate the interaction schemes. Before a decision is taken, or before an owner is issued a permit to do some works, or before a permit is issued to develop a site, an executive body should present the draft decision to the regional expert agency. Depending upon the specific federal land, depending upon its specific legislation, the expert agency may draft their recommendations or opinion, or even decline the draft decision so that it be amended and improved. So if there is no positive resolution of the expert agency, the executive body cannot take any decision. This structure is pretty complex in the land where I work, that's Northern Rhine-Westphalia. We have an executive body organized in 3 levels. The bottom level is the municipal agency for heritage protection. Supervising them is the Heritage Protection Agency at the district level, and at the very top we have the Ministry of Construction of the land. In parallel to this executive vertical, we have the expert agencies integrated into the regional associations. In the west of the land, that's the Rhineland Regional Association, and in the east is the Westphalia-Lippe Regional Association. Each of the associations has 2 departments, the Department for Architectural Heritage Protection and the Archaeological Heritage Protection Department. These departments act as expert agencies, kind of supervising the activities of the executive bodies. In small lands like Berlin, they are a town and a federal land all in one. The organizational chart is a bit simpler. They have 2 executive bodies. At the top level, it's the government of the land of Berlin. That's the Department of Urban Development of the land of Berlin, and the executive bodies from the bottom to the top. At the bottom, they are at district levels. The districts of Berlin are meant here. And in parallel, we have the Land Agency for Heritage Preservation. They act as a consultative body, and they should approve all the decisions of executive bodies. In fact, the Berlin situation is such that the expert agency can veto any draft decision so that it be amended and improved. So what are the mechanisms of actual protection and preservation of heritage? Let me tell you about the procedure of including the property into the protected sites list. There are 2 different systems here. Both systems work in Germany. One of them is the declaration-based system, or ipso lege system, and the so-called constitutive system, which can also be called the administrative act system. So what are the differences between the 2 systems? The systems are different because a site can be included into the protection list is attached to great different significance. The declarative system on the left means that an expert agency first identifies a new site. The identification is done either upon a request from the owner or upon the information filed by some local historian enthusiasts, or the information comes from stock-taking or inventory. There is a cultural expert assessment carried out, and the agency may decide that yes, really, this property should be classified as cultural heritage. Then the site is included into the register. It's registered, and after that, it's eligible for state protection. The administrative act system the other system is a bit more complicated. It all starts with a specialized agency, the expert agency, identifying a new site, but after that it can only recommend the executive body to include the site into the register. The executive body then decides whether or not the newly identified site shall be registered as a listed site, and if they agree with the cultural expert assessment results, then they notify the owner of the building or site, and that's an individual administrative act. After that, two options are possible. Either the owner agrees with the decision to list the building or site or property, and then the property becomes a protected asset. Second option, if the owner does not agree, he can challenge this decision either administratively or he can file a lawsuit. Then it can take months or even years for the administrative court, the higher administrative court, to come to an award, whether or not the executive body decision was justified or not, whether it was legitimate or not. So very briefly, let me explain the procedure for the issuance of permits. An owner who is willing to do repairs or restoration or adaptation of the heritage of the protected property, he should file an application to the local executive authority, the department in charge of heritage protection. With the application, he shall submit supporting documents, and the executive body then makes up a draft decision and files it for approval to the expert agency. Once the approval is given, and at best it should come out with recommendations. Then it's all filed back to the applicant, and the works are then carried out, and they are supervised by the executive body. And finally, the last procedure here are the measures of the administrative sanctions mentioned here today several times already. So what happens if the owner is negligent about properly maintaining the protected property? The executive body will issue an order of repairing the neglected property. If the owner carries out repairs without first getting the approvals and permits, then the agency can issue an order to restore the status quo or to suspend the repair works. Administrative sanctions can also be imposed, like a fine, or instead of a fine, the executive body can do the necessary works, can complete the necessary works at the cost, at the expense of the owner. They will outsource an independent company, and then they will bill the owner. If the bill is not paid, then the court-martial will visit the owner. To complete my presentation, I would like to say that we are trying to strike the balance between proper cultural heritage protection and the right of property protection on the other side. There is no priority of private property protection in Germany, but nevertheless there are constant and ongoing conflicts. The administrative sanctions we use look very well on paper, but in real life there is a weak link here. And the weak link of all these administrative sanctions is the guarantee of private property. Why? Because by definition of the Constitutional Court, the guarantee of private property means the right of a citizen to be economically active. And based upon this definition, the Constitutional Court believes that any movable or immovable property shall generate a profit to its owner. If it does not generate a profit, the citizen cannot exercise his right of economical activity. And if a heritage protection agency issues an order for the property to be restored, any owner can decline this order on the grounds that this protection asset is not generating any profit, which means that the costs of maintaining the assets are not covered by profits generating by operating the asset. And that means that the Heritage Protection Agency has his hands bound, so to speak. We cannot do anything about the costs if they are not covered by the revenues generated by the property. That's it. Thank you for your attention. They ask for a clarification. What will be the sanction? The actual fine, how much is that? What's the amount? There are very different administrative fines, and the amounts are different. For example, if a fine is imposed as a sanction for illegal works, in this case, it's up to 500,000 euros in my land for a rank-and-file owner of a rank-and-file property. For example, a peasant's house occupied by 2 teachers, a family of teachers. But if we're talking a major investor planning a major investment project, but one of the buildings involved in the project is listed, or a group of buildings, for example, if it's a brownfield with old industrial buildings, he might prefer to pay the 500,000 euros max and knock down the historical buildings and do a brownfield construction project. But we don't have protection of plots. We can use the alienation law or foreclosure if it's an ultima ratio way to effect protection of a property. The property should proceed to exist. If the property is destroyed, then there can be no foreclosure, even though sanctions can be imposed. But they will be punitive sanctions. You can only take away a property which is neglected and properly maintained. And in this case, you can explain that the government or the state will invest money into the site. But the enforcement measures are something different. If the owner from the outset says that he's not going to comply with the requirements, then you can try to motivate him to comply. And as motivation or as an incentive, you offer a certain amount to be paid to the national exchequer. But here we are talking hundreds of thousands of euros. This is a measure of enforcement, not a punitive measure. Thank you very much, dear colleagues. I would like to thank the presenter, and I have more questions which I shall ask the presenter personally. Now we're supposed to have a break, and let us please reconvene in this room in 15 minutes. Thank you.